So today we are diving into a topic that is crucial for anyone planning their estate, which is about the difference between a will and a trust and which one might actually be better for you. So whether you're starting to think about your estate plan or you're updating an existing one, understanding these tools is very key. So this video is ultimately going to help you choose which one is better for you, and please watch this video till the end because I'm actually going to reveal which option is the best for you. But before we do that, I've released two important videos where I actually explain what is a trust and what is a will. So go and watch those videos first, guys, before you watch this one so that you can understand everything that I'm talking about. So please note, guys, that I'm not a financial advisor and none of my videos constitute as financial advice. If you're seeking for any financial advice or a financial advisor, then please be sure to look for someone who is certified and also who is registered with the FSCA. So first, let's define what a trust and a will is. So a will is a legal document that outlines how you want your assets to be distributed after you pass away. So it allows you to name your executor to manage your estate, appoint guardians for minor children, and also specify how your debts and taxes should be paid. So a trust, on the other hand, is a legal arrangement where a trustee holds and manages assets on behalf of beneficiaries. So there are different types of trusts, but the most common one for estate planning is a revocable living trust, which you can actually change or revoke during your lifetime. So before we talk about the difference between a trust and a will, let's first talk about their key similarities that they have between them. So number one is estate planning tools. So both wills and trusts are essential tools used to manage and distribute an individual's assets after their death. So they ensure that the person's wishes are followed regarding who receives their property and also other assets. Number two, designation of beneficiaries. So both documents allow individuals to specify who will inherit specific assets. So this ensures that items or funds go to designated people such as family members or friends. Revocable nature. So both wills and revocable living trusts can be modified or revoked by the person who created them, as long as they're still alive and mentally competent. So this also allows for flexibility to adapt to changes in circumstances or preferences. Legal requirements. So both they must adhere to specific legal formalities to be valid, such as being signed, witnessed, and sometimes notarized. So this ensures that documents are legally enforceable. Professional assistance. So drafting both wills and trusts often requires the assistance of legal professionals to actually ensure that they comply with the state laws and effectively convey the individual's wishes. And specifying conditions. So both can set conditions that must be met for beneficiaries to receive their inheritance. So this might include reaching a certain age, completing education, or meeting other specified criteria. Estate management. So they can both appoint someone to manage the individual estate or assets. So in a will, this person is known as an executor, while in a trust, this role is actually filled by a trustee. So these individuals are responsible for carrying out the terms of the will or trust. So these similarities makes wills and trusts complementary tools that can be used together for comprehensive estate planning, ensuring both flexibility and also clarity in how individuals' assets and wishes are handled. So those are the similarities between the two. Now let's go back and discuss the differences between the two. So number one is probate process. So a will must go through probate, which is a court supervised process for distributing assets, so which can actually be very time consuming and costly. While on the other hand, a trust actually avoids probate, allowing for the faster and more private distribution of assets. So number two is privacy. So a will actually becomes a public record once it goes through probate, meaning that the details of assets and beneficiaries are accessible to the public, whilst the trust remains private and does not become a public record. So this ensures privacy of the asset distribution. So number three is effective date. So a will takes effect only after the death of the testator, providing no control over assets during the individual's lifetime. But a trust can be very effective immediately upon creation or the grantor's death, allowing for asset management and distribution during the grantor's lifetime. Number four is control over assets. So will provides no control over assets during the testator's lifetime. Directives only apply after death. But when it comes to a trust, the trust offers control and management over assets during the grantor's lifetime and also allowing changes and adjustments when needed. Number 5 is types. So wills generally are actually one type with variations such as living wills for healthcare decisions. But when it comes to trust, a trust can be revocable or irrevocable with various subtypes tailored to specific needs and also objectives. And number 6 is flexibility. So a will can be changed or revoked as long as the testator is alive and competent, offering flexibility in estate planning. When it comes to a trust, a revocable trust can be altered or terminated by the grantor, providing flexibility in managing assets during the grantor's lifetime. The number 7 is guardianship. So with the will, you can appoint guardians for minor children, ensuring their care and financial support. And when it comes to a trust cannot appoint guardians for minors. Guardianship provisions are typically addressed in the will rather than the trust. So number 8 is asset coverage. So wills only addresses assets solely in the testator's name, excluding jointly owned or trust assets. But a trust can actually include a wide range of assets, including real estate, investments, and also personal property, and also providing comprehensive asset management and also distribution. So number 9 is tax planning. So the will generally does not offer substantial tax planning benefits, but primarily focusing only on asset distribution. But certain trusts can actually offer tax advantage and also help minimize estate taxes through strategic planning and also asset protection measures. So these differences highlight the unique features and advantages of wills and trusts, emphasizing the importance of considering individual circumstances and objectives when creating an estate plan. So guys, now let's talk about the cost difference between the two, and please note that the costs associated with creating and managing a will and a trust can vary significantly based on several factors, including the complexity of the individual's estate, the specific services required, and the professionals involved. So let's first talk about the drafting cost of a basic will. So the cost for drafting a simple will by a professional such as an attorney or a financial advisor can actually range from approximately 500 rands to 2,500 rands. And the drafting cost for more complex wills that may include detailed provisions for minor children, multiple beneficiaries, or specific bequests, the cost can actually range from 2,500 rands to 10,000 rands or more. So upon death, the executor of the estate is actually entitled to a fee for administering the will, which may actually be regulated and can be up to 3.5% of the estate's value plus value-added tax. So additional fees may actually apply for legal and administrative work during the probate process, and this can be very different. The costs may be very different according to where you actually make your will and who's actually doing that will. So now let's talk about the creation cost of a basic trust. So establishing a basic trust can actually cost anywhere from around 5,000 rands to actually 10,000 rands. So this includes drafting the trust deed and also registering the trust. And for more complex trusts that may involve extensive asset management provisions, tax planning, or multiple beneficiaries, the cost can actually range from 10,000 rands to 30,000 rands or even more. So now let's talk about the management and administration of a trust. So the annual administration fees of a trust often require ongoing management, which can actually incur annual fees. So these fees can actually typically range from 0.5% to 2% of the trust assets per year. So this actually depends on the complexity and also the services that are actually being provided. So if a professional trustee such as a bank or a trust company is appointed, they will charge for their fees. So usually a percentage of the trust assets are the ones that are being charged. Number 3 is legal and tax services for a trust. So first, let's talk about the legal fees of a trust. So ongoing legal advice for managing the trust and ensuring compliance with the relevant laws can actually add to the cost. And when it comes to tax filing fees, trusts can actually need to file annual tax returns, which may require the service of an accountant, adding to the overall cost also. So while a will is generally less expensive to create and manage initially, the probate process can actually incur significant costs upon death. While a trust on the other hand have a higher upfront and ongoing costs, but can actually offer greater control, privacy, and potentially lower costs in the long term by avoiding probate. So the choice between a will and a trust should be made based on the individual's specific needs, estate complexity, and also financial situation. And consulting with an estate planning professional can actually provide tailored advice and also cost estimates. So which one is better? So guys, this actually depends on your individual's needs and circumstances. If you actually want a straightforward, inexpensive way to specify your wishes, a will might actually be very sufficient. But if you have more complex estates and you want to avoid probate or plan for incapacity, a trust could actually be a very good choice. So remember guys, it's always a good idea to consult with an estate planning attorney to determine what's best for you. And if you actually found this video very helpful, don't forget to like and subscribe and hit that notification bell for more content like this. So guys, thank you for watching and I'll see you next time.